While my husband and I were on vacation, our son sold our house to pay off his debts. He laughed. "You're homeless now." I just smiled and said, "The house you sold was actually—" Good day, dear listeners. It's Clara again. I'm glad you're here with me. Please like this video and listen to my story till the end, and let me know which city you're listening from. That way I can see how far my story has traveled. My name is Dorothy Callahan, and for most of my life, I believed that if you raised your children with love, patience, and a firm sense of right and wrong, they would carry those values into the world like a lantern in the dark. I taught 6th grade English for 31 years in Maplewood, Ohio. I knew every child in that school by name, knew their struggles, their small triumphs, their hidden fears. I believed in people. I still do, mostly. But what happened the summer I turned 68 taught me that believing in someone and trusting them blindly are two very different things, and confusing the two can cost you everything. Frank and I had lived in our house on Birchwood Lane for 42 years. We raised Marcus there, painted every room at least twice, buried 2 dogs in the backyard beneath the old oak tree. The house wasn't grand, 3 bedrooms, a wraparound porch, a kitchen that smelled like whatever I'd baked that morning. But it was ours, in every sense of the word. Frank had retired from the post office at 67, and we'd settled into the easy rhythm of people who had earned their quiet. Morning coffee on the porch, evening walks around the block, Fridays at the Hendersons for cards. Marcus had always been our complicated one. Not bad. I want to be clear about that because a mother notices the difference. But complicated. He chased money the way some men chase adventure, always certain the next deal would be the one that changed everything. He'd been in sales, then in real estate, then in something he vaguely called consulting that Frank and I never fully understood. He'd borrowed money from us 3 times over the years. Once for a business opportunity that evaporated in 6 months, once to cover what he called a cash flow problem, and once, 3 years ago, for an amount that made Frank go very quiet at the dinner table. We gave it to him each time. He was our son. The signs had been there before the trip, and I knew it even then, though I chose to read them charitably. That's what mothers do. In March, Marcus had called twice in 1 week asking about the house situation, whether we'd thought about downsizing, whether we'd ever considered a reverse mortgage, whether we had an updated will. I told him we were fine and changed the subject. In April, he'd shown up unannounced on a Tuesday morning while Frank was at his cardiology appointment. He walked through the rooms slowly, the way a person does when they're measuring something. I made him coffee and watched him. He smiled the whole time, that wide, easy smile that used to charm his teachers and had charmed me for decades. I told myself he was just visiting. In May, Frank and I booked our trip to Portugal. We'd been planning it for 2 years. 10 days in Lisbon and the Algarve, a celebration of Frank's 71st birthday and our 45th anniversary. We told Marcus well in advance. He helped us download a translation app on my phone and hugged me at the door before we left. "Have the time of your life, Mom," he said. I remember thinking he seemed almost relieved. Portugal was everything we'd hoped for. Frank ate grilled fish every single day. I filled half a journal. We walked along cliffs above the Atlantic and held hands like we were 30 again. For 10 days, I didn't think about mortgages or consulting businesses or the particular tension that had lived in my chest for the past several months whenever Marcus called. I let it all go. We came home on a Thursday afternoon in late June, our suitcases still smelling of sunscreen. The taxi pulled onto Birchwood Lane, and I felt that particular warmth of returning. The oak tree, the porch, the window boxes I'd planted with petunias before we left. And then I saw it. A lockbox on the front door. A real estate sign in the yard. Not our realtor's sign, a company I didn't recognize. and Marcus's car in the driveway. He was sitting on the porch steps. He stood when he saw us and he was smiling. "Welcome home," he said. Then he laughed, a short, bright, almost gleeful sound. "Well, welcome back, I should say, because this isn't exactly your home anymore." Frank went very still beside me. I felt the suitcase handle in my hand, the warmth of the June afternoon, the absurdity of the petunias still blooming in their boxes. "Marcus," my voice came out flat. "What did you do?" He spread his hands like a man presenting a magic trick. "I sold it, Mom. The house. I had debts, serious debts, and I needed to act fast. I had power of attorney from that document you both signed in 2019. I found a buyer. I closed the deal 2 weeks ago." He looked at Frank, then back at me. His smile didn't waver. "You're homeless now, both of you." He actually laughed again. "Look on the bright side. You just came back from a vacation. Think of this as an extended one." I looked at my son's face. The face I had kissed goodnight for 18 years, the face I had driven to emergency rooms and graduations and heartbreaks. And I felt something inside me go very quiet. Not the quiet of defeat. The quiet of someone who has just realized exactly what game is being played. I smiled at him. "Marcus," I said calmly, "the house you sold wasn't actually yours to sell." His smile flickered, just for a second. "What does that mean?" he said. "It means," I said, picking up my suitcase, "that someone made a very serious mistake today, and it wasn't me. I didn't go inside the house that night. I couldn't. It wasn't mine to walk into anymore. Or so Marcus believed." Frank and I drove to the Holiday Inn on Route 40, the one near the old shopping center, and we sat on the edge of a stiff motel bed, with our suitcases still packed and the air conditioning rattling in the window. And that was where I finally allowed myself to feel the full weight of what had just happened. Frank didn't say much. He sat with his hands on his knees and stared at the carpet, and I recognized the particular silence of a man trying not to let his wife see how frightened he was. Frank had always been that kind of man, strong in the quiet, careful way. But that night, I could see the fear in the set of his jaw, and it broke something open in me. How does it feel to be told you no longer have a home? I can tell you exactly how it feels. It feels like the floor has been removed from beneath your feet, but you're still standing, still breathing, still expected to function. It feels like a kind of cold that doesn't come from temperature. We had 42 years in that house. Frank's workbench in the basement. My books in the study. Hundreds of them. Paperbacks and hardcovers, and a first edition of To Kill a Mockingbird that had been my mother's. The photographs on the hallway wall. The garden I'd spent 15 years building. All of it, handed to strangers while we were eating grilled fish in Lisbon. I sat with Frank until he fell asleep. Exhausted from the travel, from the shock, from the effort of holding himself together. And then I sat alone in the thin light of the bedside lamp, and I made myself think clearly. That is something 31 years of teaching gave me. The ability to organize panic into something useful. I had learned long ago that emotion is not the enemy of action. It's the fuel. The question is whether you let it burn wildly or whether you direct it. So I made a list. Not on paper. I didn't have my notebook. But in my head, methodically. First, the facts. Marcus had used a power of attorney document Frank and I had signed in 2019, following Frank's first cardiac episode. We had given Marcus limited power of attorney for medical and financial emergencies so that if anything happened to us, he could act on our behalf. What Marcus apparently believed, what he was gambling on, was that this document gave him the authority to sell our home. What he did not know, because he had never been told, was that the house on Birchwood Lane was not held in our names alone. 11 years ago, on the advice of our estate lawyer, Gerald Fitch, Frank and I had placed the property into a family revocable living trust, the Callahan Family Trust. The beneficiaries were Frank and me. The trustees were Frank and me. The house, legally speaking, was trust property. And a standard power of attorney does not convey the authority to act as trustee of a trust. Marcus had sold something he had no legal right to sell. Second, the question of the buyer. Whoever had purchased the house had either been complicit in something fraudulent or, more likely, had been deceived themselves. That was an important distinction. It meant there was another injured party, and that party might become an ally. Third, Gerald Fitch. He was 74 now, semi-retired, but still practicing. He had written the trust documents himself. If anyone understood the exact legal landscape of what had just happened, it was Gerald. Fourth, Marcus, my son, who had sat on my porch steps and laughed. I want to be honest about what I felt in that motel room, because I think honesty matters more than dignity here. I felt grief, not just anger, grief. Real, chest-tightening grief, the kind you feel when you lose something you can never fully get back. Not the house. I felt grief for the version of Marcus I had believed in. The boy who used to bring me wildflowers from the backyard. The teenager who cried when our first dog died. Somewhere between that boy and this man, something had broken, and I hadn't seen it clearly enough. And that was its own kind of failure. I sat with that feeling for exactly 20 minutes. Then I put it away, because here is what I knew, sitting in that Holiday Inn room at 11:30 at night. Marcus had made a catastrophic legal error. He had moved fast, acted recklessly, and assumed that his elderly parents would be too shocked and too frightened to fight back. He had counted on our helplessness. He was wrong. The plan that began forming in my mind that night was not complicated. Complicated plans fail. Simple plans, built on solid ground, endure. I would contact Gerald Fitch first thing Friday morning. I would request a full copy of the trust documents. I would find out exactly who had purchased the house, through what agency, and under what representation. And then, quietly, carefully, without warning Marcus of a single move, I would begin the process of unwinding everything he had done. Frank would worry. He would want to call Marcus, to confront him, to demand explanations. I loved my husband for that instinct. But I knew that calling Marcus now would be the worst possible move. It would give him time to lawyer up, to construct a story, to move money. No, silence was my first weapon. I turned off the lamp and lay down beside my sleeping husband and stared at the ceiling in the dark. Was I frightened? Yes, of course I was. But underneath the fear was something steadier. Something I recognized from 31 years of standing at the front of a classroom and facing whatever the day brought. I was ready. I called Gerald Fitch at 8:15 Friday morning from the motel parking lot, standing in the already warm June air while Frank showered inside. Gerald's assistant said he was in a meeting. I said my name and told her it was urgent. Not an emergency, I was careful about my word choice. Because emergency makes people think of hospitals and car accidents, and I didn't want emotion clouding the first impression. I said, "Please tell Mr. Fitch that Dorothy Callahan needs to speak with him today regarding the Callahan Family Trust. It's a legal matter of some seriousness." He called me back in 11 minutes. Gerald Fitch had known Frank and me for over 20 years. He was the kind of lawyer who remembered your children's names and sent Christmas cards. The kind who made you feel that the law was something that could actually protect ordinary people if they understood how to use it. When I explained, calmly, in sequence, what Marcus had done, what he had claimed, and what we had come home to, Gerald was quiet for a long moment. "Dorothy," he said finally, "do you have any documentation of the sale? A notice? A letter? Anything?" I told him that Marcus had been at the house and that I'd seen the sign and the lockbox. Gerald said he needed to pull our trust documents. He kept physical copies in his files, and that he wanted to meet with Frank and me in person that afternoon. He said something else, too, something I turned over in my mind for the rest of the morning. If the house was titled in the trust and the deed reflects that, then what Marcus did was not just a civil matter. He didn't finish the sentence. He didn't need to. We met Gerald at his office on Garrison Street at 2 o'clock. His office smelled like old books and wood polish, the kind of smell that belongs to rooms where serious things get decided. He had the trust document spread across his desk when we arrived, along with a printout he'd requested from the county recorder's office. The property transfer record for 4,417 Birchwood Lane. I watched his face as he read. Gerald Fitch had a lawyer's face, trained for neutrality. But I had known him long enough to read the small signals, the slight tightening around his eyes, the way he set down one page and picked up another with a particular deliberateness. "The deed," he said slowly, "was recorded in the name of Frank and Dorothy Callahan individually, not in the name of the Callahan Family Trust." The room went quiet. "But we transferred it into the trust in 2013, Frank said. "You did the paperwork yourself, Gerald." Gerald nodded. "I did. And I have the trust document, signed and notarized, showing the intent of transfer. But the deed at the county recorder's office was never updated to reflect the trust as title holder." He looked at us over his reading glasses. "It's an administrative error. It happens more than people realize. The trust is created, the transfer intent is documented, but the deed itself isn't re-recorded in the trust's name. Technically, on paper, the property still showed as held in your personal names." I processed this in silence. So Marcus's power of attorney would have appeared to a title company doing a routine search to authorize him to act on your behalf as individuals. "Yes." Gerald folded his hands on the desk. "This is not a simple situation, Dorothy, but it is not a hopeless one. The trust document establishes intent clearly. We have the original transfer documentation, and there is the question of what Marcus disclosed, or failed to disclose, to the buyer and to the title company." He then showed us the printout from the county recorder. The property had been sold 3 weeks ago for $247,000, significantly below market value for Birchwood Lane, where comparable homes had recently sold for $310,000 to $330,000. The buyer was listed as a limited liability company, Cornerstone Property Solutions, LLC. That detail mattered. An individual buyer might have been an innocent victim. An LLC purchasing residential property at a steep discount was a different story. It suggested either a wholesale real estate operation that knew it was buying a distressed or legally ambiguous property, or a company that had been informed of unusual circumstances and had priced accordingly. Gerald made copies of everything and sent us home, to the motel, with a folder of documents and instructions not to contact Marcus or anyone connected to the sale. He said he would make calls over the weekend and have a clearer picture of our legal options by Monday. But I had already seen what I needed to see. That evening, while Frank watched the news, I called my daughter-in-law Brenda's sister, Patrice. We had always gotten along, and Patrice had a loose tongue when she felt sympathetic. I didn't ask about Marcus directly. I asked how Brenda was doing, mentioned that we were back from Portugal, made small talk. And then Patrice, in the way of people who cannot hold a secret they believe you already half know, said, "Well, I guess things have been pretty stressful with the gambling situation." There it was. Not business debts. Not a cash flow problem. Gambling. Marcus had gambling debts, and he had sold our home to pay them. And he had laughed on the porch of that home like a man who believed he had gotten away with something. I thanked Patrice for the call and set my phone down on the motel nightstand. Outside, a truck moved along Route 40, its headlights sweeping briefly across the curtains. I had everything I needed to begin. Monday arrived with the particular clarity that follows difficult weekends. The kind of clarity that comes not from rest, but from decision. Frank and I had spent Saturday and Sunday in the motel, going through every document Gerald had copied for us, ordering meals from the diner down the road, speaking carefully and honestly about what we were willing to do and how far we were willing to go. By Sunday night, we were in agreement. We would pursue every legal avenue available to us. We would not negotiate with Marcus. We would not soften the blow to protect his feelings or his reputation. What he had done was not a mistake made in desperation. It was a betrayal made in calculation. And calculated betrayals require calculated responses. Gerald called at 9 Monday morning. He had spoken over the weekend with a colleague who specialized in real estate fraud and elder financial abuse, a phrase I noted carefully because it had legal weight. He had also contacted the title company that had processed the sale, a firm called Heartland Title Services, and had put them on formal notice that the transaction was being disputed. Heartland, predictably, had gone silent and referred everything to their legal team. That was expected. What was more interesting was what Gerald had discovered about Cornerstone Property Solutions, LLC. It had been registered in Ohio 14 months ago, had made 11 cash purchases of residential property across 3 counties in the past year, and shared a registered agent address with 2 other LLCs. It was, Gerald said, almost certainly a wholesale real estate operation, one that purchased distressed properties at significant discounts and resold them quickly. They may not have known the specific legal issue with the title, Gerald said, but they knew they were buying fast and cheap, which means they accepted a level of risk. That complicates their position. Gerald filed a formal notice of claim on the property with the county recorder's office that same morning, creating a cloud on the title, meaning Cornerstone could not cleanly resell the house until the dispute was resolved. He also began preparing a petition for declaratory judgment, asking the court to confirm that the Callahan Family Trust was the rightful owner of the property and that the sale had been conducted without authority. The cloud on the title was the move that reached Marcus. I found out how it reached him at approximately 2:15 Monday afternoon when he appeared in the parking lot of the Holiday Inn. I was walking back from the vending machine at the end of the corridor when I saw his car. The silver Audi he'd leased 2 years ago, the one Frank had quietly told him was too expensive for his income. Marcus was standing beside it, and he was not smiling. "What did you do?" he said, before I had closed half the distance between us. I stopped. I was holding a bottle of orange juice and a packet of crackers, which is not a particularly powerful image, but sometimes ordinary details are the most honest ones. "I'm not sure what you mean, Marcus. You called a lawyer. You put a cloud on the title. The buyer is calling me, the title company is calling me, and my own lawyer is telling me this is going to be ugly." His voice had an edge I hadn't heard before, not the sharp, bright cruelty of the porch, but something closer to panic, wearing anger as a coat. "You're going to destroy everything. I needed that money, Mom. I needed it. You don't understand what I owe these people." "What people?" I wanted to ask. "What kind of people does a gambling debt lead you to?" But I didn't ask, because this was not a conversation. This was pressure. "You sold our home without our knowledge or consent," I said. "You used a legal document that did not give you that authority, and you laughed at us." I was stressed. "Marcus," I kept my voice level, "I am not going to discuss this with you here or anywhere without Gerald Fitch present. If you want to communicate about this matter, you contact Gerald. That's all I have to say." He stepped closer. Not threatening. He wasn't that person, not physically. but attempting the closeness of intimidation. If this goes to court, it's going to become public. You know that. People in this town know us. Do you want everyone knowing our business? Do you want Dad's heart condition in the middle of a lawsuit? There it was. Frank's heart. The oldest lever. I looked at my son for a long moment. Really looked at him. The way you look at something when you're memorizing it. And I felt sadness and something cleaner than anger. Resolve. "Goodbye, Marcus," I said, and I walked back to our room. He sat in the parking lot for 20 minutes. Then he drove away. That evening, I called Gerald and reported the encounter. He noted it formally. He also told me that the declaratory judgment petition had been filed and that Marcus would be served notice within the week. And then, because Gerald told me to, and because Frank needed it, and because I had earned it, I allowed us 3 days of stillness. We drove to Frank's sister Patricia's house in Dayton, where there was a spare room and a good porch and no lockboxes on anyone's doors. I slept. I ate Patricia's cooking. I watched Frank's shoulders drop 2 inches over the course of 48 hours. I didn't stop thinking. I don't think I'm capable of that. But I let the thinking be slow and deliberate instead of urgent. 3 days, and then back to work. When Frank and I returned from Dayton on Thursday afternoon, the motel room felt smaller, but more manageable. The way problems always feel after sleep and good food and the company of someone who loves you without conditions. Patricia had sent us back with a casserole, 2 bottles of wine, and a look on her face that told me she understood more than we'd said out loud. Frank's sister had always been perceptive in the way of people who grew up watching closely. Gerald had left a message while we were gone. Marcus had retained a lawyer, a man named Douglas Preer, whom Gerald knew by reputation as someone who specialized in creative estate and property disputes. The word creative in the legal context is rarely a compliment. It meant Preer would look for angles, exceptions, ambiguities. Gerald was not concerned, but he was alert. Good lawyers respect the opposition until they've proven it isn't worth respecting. Brenda called me Friday morning. Brenda had been Marcus's wife for 16 years. She was a practical woman, good at logistics, less good at empathy. And she had always maintained a polite, slightly wary relationship with me, the way 2 people do when they both love the same complicated man and understand that the love requires negotiation. I had never disliked Brenda. I had simply never fully trusted her, because people who are fundamentally loyal to their spouses are capable of justifying nearly anything those spouses do. That is not a character flaw. It is a kind of love. But it is also a kind of danger. "Dorothy," she said, "I think we should talk, just the 2 of us, woman to woman." I agreed to meet her for coffee at a place called Sunrise Cafe on Elmwood. Neutral ground, public, my choice of location. I arrived 5 minutes early, took a seat where I could see the door, and ordered black coffee. Brenda arrived looking tired and more carefully dressed than the occasion required, which told me she had prepared. She was wearing the kind of composed expression that takes effort to maintain. She began with an acknowledgement. Marcus had made a terrible mistake, she said. She was not defending what he'd done. She understood why we were upset. Then she moved, with the efficiency of someone who had rehearsed, to the offer. Marcus was prepared to arrange alternative housing for Frank and me to pay rent on a suitable apartment for 12 months while the legal situation was sorted out, and to negotiate a financial settlement that would, in her words, make everyone whole. Could she hear herself? I wondered that, honestly. Did she understand what she was describing? She was offering 12 months of rent on a house worth over $300,000 that her husband had sold without our consent, on the home where I had lived for 42 years, as though this were a reasonable exchange, as though what had been taken was a sum of money and not an entire life made concrete. Brenda, I said, what Marcus did is not a misunderstanding to be sorted out. It is a legal violation. Gerald Fitch is not pursuing this because our feelings were hurt. He is pursuing it because there is a legitimate legal case. Lawyers make things worse, she said. You know that. Once this gets into court, it becomes a war. Do you want a war with your own son? Did I want a war? No. But sometimes a war finds you whether you want it or not. Sometimes the opening shot has already been fired before you even knew a conflict had begun. I drank my coffee and I looked at her. Tell Marcus to speak to Gerald, I said. That's the only conversation I'm having about this. She left the cafe with her coffee untouched and her composure slightly less intact than when she'd arrived. I sat for a while after she left. The cafe was filling up with the Friday lunch crowd. Teachers from the elementary school nearby, I recognized two of them, former colleagues. Ordinary life, continuing in its ordinary way, indifferent to the extraordinary things happening inside individual lives. And that, actually, was when I understood what I needed. I had Gerald. I had Frank. I had Patricia in Dayton. But I was living in a motel, separated from my community, and I was beginning to feel the particular loneliness of a person fighting a private battle in a public world. I needed to stop hiding. I called Ellen Marsh that afternoon. Ellen had been my closest friend for 30 years, retired principal, sharp mind, and the kind of woman who, when presented with injustice, becomes efficient rather than emotional. I told her everything, all of it. She listened without interrupting, which was one of the things I had always valued about her. When I finished, she said, "Where are you staying?" I told her, "The Holiday Inn on Route 40. "That's absurd," she said. "You'll stay with me." And just like that, Frank and I had a bedroom in Ellen's spare room, home-cooked meals, and someone who would sit with me at the kitchen table each evening while I reviewed Gerald's updates and asked the kinds of questions that helped me think more clearly. Ellen knew a county commissioner. She knew a journalist at the local paper who covered housing fraud. She knew, more importantly, that the best thing she could give me wasn't information or connections. It was witness. Someone who knew what was happening and would remember it accurately. I was no longer alone in this, and that changed everything. It was Ellen who told me they were coming. She had a glass panel front door with a view of the street, and she happened to be in the hallway on a Tuesday morning about 10 days into our stay when she saw Marcus's silver Audi slow down and park across the street. She came to find me in the kitchen, where I was reading Gerald's latest update on my laptop, and she said simply, "Your son is outside." Then she went and sat in the living room with her book, close enough to hear, far enough to allow me privacy. That was Ellen. I went to the front door and opened it before Marcus reached the porch steps. Brenda was with him. They were dressed casually, deliberately, I thought, in the way people dress when they want to project approachability. Marcus was carrying a small paper bag from the bakery on 5th Street. My bakery. The one where I had bought bread every Saturday for 20 years. "We wanted to come by," Marcus said, "just to talk. No lawyers, no formal anything, just family." I looked at the bag. I thought about what it meant that he had gone to my bakery, that he knew exactly which gesture would feel most like home. "Come in," I said. We sat in Ellen's kitchen because the living room felt too formal and the kitchen felt honest. Ellen excused herself to her garden. The bakery bag sat unopened on the table. Marcus began with an apology. It was a well-constructed apology, specific enough to seem genuine, vague enough to avoid admitting legal liability. He acknowledged that selling the house without telling us had been wrong. He said the pressure of his financial situation had made him desperate. He said he loved us. He looked genuinely like a man who was ashamed. I am experienced enough to know that shame and remorse are not the same thing. Shame is about how a person feels about themselves. Remorse is about what they're willing to do differently. Marcus felt shame. But what he wanted, underneath the careful words and the bakery bag, was not to make things right. He wanted the lawsuit to go away. "Mom," he said, "if this goes to court, if Gerald files everything he's threatening to file, there's going to be a fraud investigation. You understand what that means. It means my name, our family's name, in the local paper. It means depositions. It means Dad sitting in a courtroom." He paused. "Dad's heart, Mom. Is this worth his health?" There it was again, Frank's heart. Second time. "Frank is in the garden," I said quietly. "He is not as fragile as you seem to need him to be." Brenda leaned forward. "Dorothy, we're not threatening you. We're asking you to think about what this does to everyone. Marcus has children, your grandchildren, Kyle and Sophia. They're 12 and 9. Do you want them growing up knowing their grandfather took their father to court?" I sat with that for a moment. Kyle and Sophia. I had their school photos on the refrigerator. On our refrigerator, the one that was now inside a house that didn't belong to us. I thought about the last time I'd seen them. Kyle teaching Sophia a card trick at the kitchen table, both of them laughing. And then I thought about what it would teach them if I backed down. If I showed them that when someone does something wrong, the family closes around the wound in silence and calls it love. "What you're describing," I said, "is asking me to choose between protecting your comfort and protecting what's right. And you're using my grandchildren to make that choice feel unbearable." I looked at Brenda, then at Marcus. "I want you to understand something. I did not begin this. I did not choose this. You chose it. You chose it when you walked into a real estate office and signed papers on our home. Everything that follows is a consequence of that choice, not of mine." Marcus's composure cracked. Not dramatically, not shouting, not anything I could call a scene. But I saw it in his eyes, a flash of something ugly that had always lived behind the charm and that I had spent too many years not fully acknowledging. "You're going to regret this," he said. His voice was low. "You're going to push this, and it's going to cost you. In money, in time, in your health. Gerald Fitch isn't going to be around forever. And judges don't always side with the people who think they're the heroes of the story." Was that a threat? It had the shape of a threat without the specific content of one. A lawyer would call it ambiguous. A mother would call it what it was. "I think you should leave now," I said. They left. Marcus didn't take the bakery bag. I sat in Ellen's kitchen after the door closed, and I allowed myself exactly what I was feeling, which was fear. Real, physical fear, the kind that sits behind the sternum and makes your hands feel cold. Because Marcus had been right about one thing. This process was slow, expensive, and exhausting, and there were no guarantees. Gerald was good, but courts were unpredictable. The cloud on the title was holding, but Cornerstone's lawyers were active. This could take years. But here is what I understood about fear. After 68 years, it is loudest right before you do the thing you are most afraid to do. And once you do it, fear becomes something else. Not courage, exactly, but momentum. The particular momentum of a person who has decided that going forward is less frightening than going back. I opened the bakery bag. There were 2 almond croissants inside, my favorites, and he knew it. I ate one, it was very good, and I continued anyway. The hearing was scheduled for a Thursday in late August, 8 weeks after we had come home from Portugal to a lockbox and a laughing son. Let me describe the courtroom for you because location matters. It was not a dramatic space. Room 4 of the Maplewood County Courthouse, with fluorescent lighting and wooden benches polished by decades of nervous hands. The kind of room where ordinary people's extraordinary problems get weighed and measured and assigned a legal category. Gerald had told me to dress conservatively, to bring nothing to the table I didn't need, and to answer questions only when asked. I wore the gray blazer I'd bought for Frank's retirement ceremony. I felt, putting it on that morning in Ellen's guest room, entirely like myself. The hearing was a declaratory judgment proceeding, not a criminal trial, not yet, though the question of fraud referral had been mentioned by the judge in preliminary filings. What we were asking the court to determine was simple. Was the Callahan Family Trust the rightful owner of 4,417 Birchwood Lane at the time of sale? If yes, then Marcus's power of attorney had been insufficient authorization, the sale was voidable, and the title transfer was invalid. Douglas Prier, Marcus's lawyer, had filed a response arguing three things. First, that the trust had never been properly perfected because the deed had never been re-recorded in the trust's name. Second, that the power of attorney was broad enough to authorize real estate transactions on behalf of the grantors. And third, that the buyer, Cornerstone Property Solutions, was a good faith purchaser who had relied on valid public records. These were not frivolous arguments. Gerald had prepared for them carefully. Marcus was present at the plaintiff's table with Prier. He was wearing a tie, which I noticed because Marcus hadn't worn a tie voluntarily since his own wedding. He looked like a man performing the role of someone who was not worried. Frank sat beside me at our table. He had asked to be there, and I had not argued. The judge was a woman named the Honorable Sandra Bellows, 50-something, with the economy of gesture of someone who has heard every kind of human story and sorted them efficiently. She read the filings, asked clarifying questions of both attorneys, and then, this was the moment, she addressed the factual record. "Counselor Fitch," she said, "walk me through the chain of title as you understand it." Gerald stood. He was unhurried. He presented the original deed from 1982, the trust document from 2013, and the recorded transfer instrument, signed by both Frank and me, that had been filed with our estate attorney as part of the trust formation. He acknowledged, directly and without embarrassment, that the deed at the recorder's office had never been updated to reflect the trust as title holder. He then presented case law, 2 Ohio precedents, establishing that a properly executed transfer into a living trust is legally effective even if the deed is not immediately re-recorded, provided the intent to transfer is documented and the trust exists validly. The property, Gerald said, was equitably held by the trust. The legal title discrepancy is an administrative artifact, not evidence that the transfer did not occur. Then Prier cross-examined. And this is where things began to fracture. Prier called Marcus to speak, not in a full testimony, as this was a civil declaratory hearing, but to address specific factual questions the judge had flagged. And Marcus, who had spent 44 years being the most confident person in any room he entered, discovered that courtrooms are different from porches. The judge asked him, "Mr. Callahan, at the time you executed the sale, had you reviewed the trust documents held by Mr. Fitch's office?" Marcus said, "I didn't know there were trust documents at Mr. Fitch's office." The judge looked at him steadily. "You were unaware that your parents had established a family living trust naming their property as a trust asset?" "They never told me." "And yet," Judge Bellows said, consulting the filing in front of her, "Gerald Fitch's office records show that a letter was sent to your address in November 2013, notifying the family of the trust formation, as is standard practice. Did you receive that letter?" A pause. "I don't. I may have. I don't remember." "Did you make any inquiry with any title company, attorney, or county official about whether the property might be encumbered by a trust or other instrument before proceeding with the sale?" Another pause. Prier shifted in his seat. "I relied on the public deed records," Marcus said. "You relied on records you knew your parents had not updated," Judge Bellows said, "because the power of attorney you used was drafted in connection with an estate planning process, of which this trust was a central component. She looked at him over her glasses in a way that reminded me, painfully, of myself at the front of a classroom. Mr. Callahan, were you present at any conversation with your parents' attorney in which the trust was discussed? And here is where it came apart. Marcus said, "Not that I recall." Gerald handed me a single sheet of paper without looking at me. I had seen it before. It was a sign-in log from Gerald's office from a meeting in September 2013, a family estate planning session at which Marcus had been present and had signed his name. Gerald had found it during discovery prep. It showed, in Marcus's own handwriting, his signature on an attendance record for a meeting titled Callahan Family Trust Formation and Asset Transfer. Gerald introduced it into evidence quietly, without drama. He simply said, "Your Honor, I'd like to submit Exhibit 14 for the record." The judge reviewed it. She looked at Marcus. Marcus looked at the paper, and the confident architecture of his expression, the ease, the performance of a man with nothing to hide, simply fell. I forgot," he said. "That was 12 years ago." Prier tried to redirect. But you cannot redirect away from a signed document. You can only watch while the room recalibrates around it. I didn't feel triumph. Not then. What I felt was the particular stillness of having been patient long enough for the truth to simply appear. I had not manufactured this moment. I had only held on until it arrived. Judge Bellows did not issue her ruling that day. These things take time, and she said she would review the full record. But before adjourning, she made a statement that Gerald later told me was unusual in its directness. The court notes that the question of good faith, both on the part of the executing party and the purchasing entity, will require careful consideration in light of the documentation presented today. In legal language, that is a significant sentence. We walked out of the courthouse into the August afternoon, and Frank took my hand, and we stood on the courthouse steps in the heat, and neither of us said anything for a long moment. There was nothing that needed to be said. Sometimes silence is not emptiness. Sometimes it is the sound of something being resolved. Judge Bellows issued her ruling 22 days after the hearing. Gerald called me on a Wednesday morning. I was in Ellen's kitchen, which had become my unofficial headquarters, and read the key passages to me over the phone. The court found that the Callahan Family Trust had been validly formed in 2013 and that the intent to transfer the property at 4,417 Birchwood Lane into the trust had been sufficiently documented, notwithstanding the administrative failure to re-record the deed. Under the principle of equitable title, the trust was recognized as the beneficial owner of the property at the time of the contested sale. The court further found that Marcus Callahan's power of attorney, as drafted, did not convey trustee authority and was therefore insufficient legal basis for the sale of trust-held property. The sale to Cornerstone Property Solutions, LLC, was declared voidable. And then the third finding, which Gerald read to me slowly. The court finds probable cause to believe that the conveyance was executed with knowledge, actual or constructive, of the trust's existence, and hereby refers the matter to the Maplewood County Prosecutor's Office for review of potential elder financial abuse charges under Ohio Revised Code, Section 2913.02. I sat down, not from weakness, from the weight of it. Because that sentence meant that what Marcus had done now lived in the criminal justice system, not just the civil one, and that the consequences he would face were no longer ones I controlled or could soften. Gerald explained what came next. Cornerstone Property Solutions, facing the voided title and the legal exposure that came with purchasing property under disputed circumstances, chose not to contest the ruling. Their attorney contacted Gerald within 48 hours of the decision to begin negotiating an orderly resolution. They had paid $247,000 for the property. The court would oversee the unwinding of the transaction and Cornerstone would pursue recovery of their purchase price from Marcus directly, which was, as Gerald put it, a problem that now belonged entirely to Marcus. The house, our house, 4,417 Birchwood Lane, with the oak tree and the wraparound porch and the petunias I had planted in May that someone else had presumably watered or let die, was coming back to us. Or rather, it had never legally left. The court had simply confirmed what had always been true. We were home. Frank cried. He sat at Ellen's kitchen table with Gerald's summary in his hands, and he cried quietly, in the way he'd cried maybe 4 times in our 45 years together, and I put my hand on his back and didn't say anything because there was nothing adequate to say. The criminal referral moved on its own timeline, separate from us. The prosecutor's office contacted Gerald in September. Marcus was interviewed. Prier accompanied him. The investigation took several months, as these things do. In February of the following year, Marcus was charged with 1 count of theft by deception under Ohio's Elder Financial Abuse Statute, a felony in the 3rd degree, carrying potential penalties of up to 5 years imprisonment and fines. The charge also triggered civil consequences. He was required to make restitution, and Cornerstone's civil suit against him for recovery of the $247,000 purchase price moved forward independently. We did not attend the criminal proceedings. We did not need to. We had already been given what we needed: acknowledgement, in the language of the law, that what had been done to us was wrong and that there were consequences. Marcus lost the Audi. It was a lease he could no longer afford. He and Brenda sold their own home, a house in a newer subdivision across town, to cover legal fees and the beginning of the restitution order. I learned this not by seeking out information, but by the ordinary permeability of a small community, where things become known whether you pursue them or not. He did not call me. I did not expect him to. What I did do in late October was return to 4417 Birchwood Lane for the first time since we had come home from Portugal. Gerald accompanied us for the formal walkthrough, along with a locksmith and a property inspector. The lockbox was gone. The real estate sign had been removed. The window boxes were bare. The petunias had not survived. But the porch was intact. The oak tree was intact. And when the locksmith opened the front door and I stepped inside, the house smelled like itself, like wood and old books and the particular quiet of a place that has stood long enough to have a character. My books were still in the study. Every one of them, including my mother's first edition of To Kill a Mockingbird, which I took down from the shelf and held for a moment before putting it back. Frank's workbench was still in the basement. We were home. We repainted the kitchen that fall. Soft yellow. A color I had wanted for years and had never quite gotten around to choosing. Frank did the trim work himself, slower than he would have 10 years ago, but no less careful. And I made coffee and handed up the brush when he needed it, and we listened to the radio the way we always had. It occurred to me, standing in that kitchen with paint on my hands, that ordinary life is not a small thing. Ordinary life, chosen deliberately and protected fiercely, is one of the most radical acts available to a person. Ellen came for dinner every other Friday. She brought wine, I cooked. Patricia drove up from Dayton at Thanksgiving, and we had 12 people at the table. Neighbors, Frank's post office colleagues, Ellen's daughter and her family. And the house was full of noise in the best possible way. Gerald Fitch retired officially in December, citing one last satisfying case as part of his timing. He referred us to a younger colleague, a woman named Sandra Park, who updated all our estate documents, re-recorded the deed explicitly in the trust's name, and made absolutely certain that every piece of paper in our legal life said precisely what it meant. I went back to volunteering at the middle school library 2 mornings a week. I liked being useful in that particular way. The smell of books, the energy of children who had just discovered a story that mattered to them. Frank started a vegetable garden in the backyard, growing tomatoes, zucchini, and more basil than two people could possibly use. He gave bags of tomatoes to the neighbors. He was proud of this in a quiet, sustaining way that was wonderful to witness. We were, in the most straightforward sense of the word, well. And Marcus? The criminal case resolved in a plea agreement. A misdemeanor charge, suspended sentence, 3 years of probation, and a formal restitution order. The cornerstone civil suit resulted in a judgment against him for $247,000 plus legal fees. He and Brenda sold their house and moved into a 2-bedroom apartment across town. Marcus was working in sales again, a lower-level position than before. Kyle and Sophia were, by all accounts, fine. I sent birthday cards. I did not know yet what our relationship would look like going forward. Some things take time to understand. And then, in May, almost a full year after our return from Portugal, Marcus called. It was a short call. He did not ask for anything. He said he was sorry, and his voice sounded different from any version of it I had heard in the past year. Just tired. Just the voice of someone who has been stripped of a particular confidence and is learning to function without it. I said, I know. I did not say it was all right. Some things change the shape of a relationship permanently, and honesty requires acknowledging that. But I did not hang up either. We talked for 7 minutes about Kyle's school play, Sophia's drawing, Frank's tomatoes. It was not reconciliation. It was a beginning, fragile, uncertain, with no guarantees. After I hung up, I went to the backyard, where Frank was tying up the tomato plants, and I sat in the garden chair and watched him. The oak tree was leafing out. A neighbor's lawnmower hummed somewhere down the block. I was home. I had fought to stay there, and that specific, particular thing, was entirely mine. If my story taught me anything, it's this. The people who count on your silence are counting on your fear. The moment you replace fear with one careful, deliberate action, one phone call, one document, one honest conversation, the power shifts. I was 68 years old and living in a motel. And I won. Not because I was powerful, because I was prepared, patient, and refused to mistake love for surrender. What would you have done? If this story moved you, please share it. And tell me in the comments, would you have called the lawyer or tried to work it out as family first? Thank you for listening.